Hello everyone, welcome to iExamB. Embrace the iExamB learning experience for 50% faster job preparation. Your phase 1 exam for SEBI Grade A Legal is nearing and it is on the 10th of January. In the past video, we had discussed in detail what should be your last 30 days strategy, given at which stage of preparation you were, which were the important topics that you could focus on, and how could you divide your last 30 days for the preparation. To give impetus to your preparation further, we had emphasized on the importance of revision and practice, and for that purpose we are starting discussion of various important MCQs from the various laws of phase 1. In this particular video, this is the first video in the discussion of the important MCQs. Here I will also be talking about the total applications that have been received for SEBI legal post in 2025, which is approximately 12,000 students. So we will understand what your competition is like so that you can move ahead with your preparation. So let's start. This is the number released by SEBI, the data that was given by SEBI in relation to the number of applications they have received for various posts that have been advertised. For legal, there are 20 vacancies, as you are aware. You have applied for this. And for the legal stream, around 11,382 students have applied. If you also include the students who applied for two streams, general and legal, another 500 students have applied. Approximately 12,000 or exactly 11,884 students have applied for the legal post. How does this compare with the past trend? If we look at the past, around 11,000 students had applied for 25 vacancies in 2023 also. In 2024, the number of vacancies were less at 5, where 5,000 students had applied. Here, a similar number to 2023 and similar number of applications is what we have received, around 12,000. Given, if I believe by the past trend, of course this is not there, we will get to know this only after phase 1 exam has been done, but if we go by the past trend, every year the number of people who appear after applying has been increasing. So anywhere between 75 to 80% at least should sit for the exam, which means 9,000 to 9,500 students should be appearing for your phase 1 exam. However, this number is still not relevant. Why? Because phase 1 exam, if you remember, the cutoff is general in nature. This is general, which means you are still not competing with every applicant. You are only competing with the best version of yourself. Here, there is a general cutoff where in paper 1, you need a minimum 30 marks out of 100. In paper 2, you need a minimum 40 marks out of 100, and in total the aggregate of these two, you need to get at least 80 marks out of 200, right? So 40% aggregate cutoff is what is required. So this is a general cutoff that you need. Still, many students do not reach the phase 2, and if we see the past trend, it is likely around 1,400 to 1,800 students should reach the phase 2 level. And this is where it is important that you ensure you are amongst that number who reach. And to help you with that, we will be discussing the important questions from various acts for your preparation. Today we are talking about the Indian Contract Act, which is a part of the overall contracts laws. There are 4 contract laws that cover your syllabus: Indian Contract, Sales of Goods Act, Indian Partnership, and Specific Relief Act. Together they form 25% of the weightage. If we look at the past trend, you will see majority of the questions come from the Indian Contract Act, which is consistently asked, whereas you may get more questions from partnership, sales of good, also 2 or 3 questions from here. If you want to see the past year questions, we had segregated them law-wise, act-wise also, and we have those videos on our YouTube channel also. So you can access those videos also from the YouTube channel, this Legal B YouTube channel, right? So let's move ahead and discuss some important questions for your preparation. These important questions have been structured in such a manner that they help you in a complete revision of all the important sections and terms, and also help you understand the application of these particular legal rules and regulations of from the Act, right? So let's move ahead. Before I move ahead, I would also like to tell you about the quick revision course and practice course that has been launched by iExamB. That consists of a lot of practice at the chapter and the section test level. You also get summaries for all the important laws of paper 2 from your phase 1 syllabus, MCQ booklets for the important laws of paper 2 of phase 1 syllabus. You also get 15 mock tests each for paper 1 and paper 2. That means 30 in total. You also have access to all the PYP files of the exam since 2020. For today, this course is available at a flat price of 2007 rupees only. You included in this is also access to the marathon sessions that we will be starting from the 25th of December. That will cover all the 4 subjects of your paper 1, that is GA, Quant, English and Reasoning, and 2 marathon sessions for comprehensive revision and practice for your legal subject with Indra ma'am. iExamB has been guiding for the SEBI legal exam since 2020, and we are proud to be associated with the selection of various SEBI legal officers over the past many years. Let's move ahead and now discuss the important questions and practice questions that will help you to revise the most important aspects for phase 1 exam from the Indian Contract Act. This is the PDF where we have detailed the important questions and the revision strategy. It's a 20-page PDF which you can download from the description of this particular video, right? So as we will discuss over here, the past trend, the exam strategy and the important practice questions. As already stated, Indian Contract as on a consistent basis does 3 to 4 questions asked every year. Some of the most important sections for you to revise are your section 13 to 20, which can account for 25% of all the questions and relate to the consent framework. Your section 56, which can be account for another 15%. Section 73 to 74 for another 10%, which relates to remedies. Section 124 to 147, which relates to guarantee, and it's critical for your SEBI financial context. And your section 182 to 237, which can account for another 12%. It relates to agency, M&A and corporate governance. A few more sections that you should not skip are your section 2 and section 10 to 12. Some SEBI specific important sections for you would be section 17, which talks about fraud, section 27, which talks about restraint, section 56 relating to frustration, and section 124 to 147 related to guarantee, right? And that's why these become even more important. So now let's move on and discuss some of the sample questions. Now these questions have been framed in such a manner while in the past we have seen direct questions come in from the Contract Act. This PDF we have created in such a manner that are asking you various conceptual and important terms and definitions from the Contract Act through an application basis. This serves 2 purposes. You are able to revise all the important aspects through these 10 MCQs given here with the detailed explanation. Plus, you will also be able to see the application, and if asked in an application format, like we are seeing the types of questions are getting a little indirect over these years, you will be ready from all aspects for your phase 1 exam. So let's look at the first question. A agrees to sell his land to B for 50 lakhs. During negotiation, A says, I am selling at this price, but I'm not really free to refuse because I am in debt. However, I'm not under any coercion from B. Which of the following statement is correct legal position under the Indian Contract Act? A has given consent but not free consent under section 14 because A is under personal duress, which is debt. A has given free consent under section 14 because B did not apply coercion and A's personal circumstances are irrelevant. A has given consent and free consent because A explicitly said that he was not under coercion from B. The transaction is void because A's consent was not absolutely voluntary under section 10, or A can rescind the contract at any time under section 19 because he lacked free consent. The correct answer over here you must have identified is answer B. Now let's look at all the important aspects which we have given in a detailed manner through an explanation over here. Section 13 talks about consent and defines it as two or more persons are said to be in consent when they agree upon the same thing in the same sense. While section 14, which has been referred to here in the question, talks about free consent, and it is defined as the consent is said to be free when it is not caused by coercion, undue influence, fraud, or misrepresentation of mistake, which is what has happened in this case. It was not coercion, which has been specifically mentioned by in the question. Now, if you see a critical distinction, section 15, which talks about coercion, threat of unlawful act causing loss or harm, as A's personal debt is not a coercion, it is not an unlawful threat by B. Further, A's personal financial distress is not equal to vitiation of the free consent under the Indian Contract Act. And B did not apply any coercion, and therefore A's consent is free. So this is the basic understanding that you can get after reading section 13 and section 14. Okay. Why other options are not relevant and correct is further how we have explained this. The conflates personal hardship and with legal vitiating factors. Personal debt is not equal to coercion as per section 15. A's disclaimer does not cure legal defects. Void contracts are for unlawful consideration, but here there is no unlawful consideration, which is covered under section 23. And section 19, which is rescission, requires actual vitiation, that is coercion or fraud, and not mere regret, which is also not being fulfilled over here. So all these other options were incorrect. Let's look at another conceptual question in an application format. Right? A sells a diamond ring to B, stating this is certified as 1.5 carats by GIA. In fact, the certification belonged to a different ring, and this ring is only 0.8 carats. A genuinely believed the certification matched, an honest mistake by the jeweler's apprentice. B sues for rescission. Under the Indian Contract Act, which statement is correct? Okay, so let's move and see what are the different statements that have been mentioned. This is a fraud under section 17. A is liable even though A believed the statement was true. This is innocent misrepresentation under section 18, and B can rescind but cannot claim damages under section 73. This is innocent misrepresentation under section 18. A can rescind and claim damages because of misstatement was factual. A is not liable under either section 17 or 18 because A did not intentionally lie. There was no mens rea. And this is fraud under section 17 because the statement was false. A's subjective belief is irrelevant over here. The correct answer over here is B, right? This is misrepresentation, but an innocent misrepresentation under section 18. B can rescind but cannot claim damages. So let's look at in detail what all these sections cover and why they do not fall into this category. Section 17 deals with fraud and is defined as fraud means and includes any of the following acts committed with intent to deceive or knowing that it is likely to deceive, but here it was innocent mistake. It was not done with an intention to deceive. Section 18 talks about misrepresentation and says the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes it to be true, right? Now, what is the distinction over here? Fraud, false statement with intent to deceive or knowing it is likely to deceive. A must have knowledge of the falsity, which he did not. Innocent misrepresentation has happened. False statement made without warranted knowledge, but A believes it is true. Here, A believed the certification match. No intent was there to deceive, and therefore this is innocent misrepresentation under section 18. Now, what are the remedies in case of innocent misrepresentation? In that case, rescission is allowed. So B can rescind the contract, but no damages under section 3 can be done, because damages apply to fraud and breach and not to innocent misrepresentation. So these are the reasons, and you can again look at all the reasons why the other options are incorrect. In this manner, in this particular PDF, you will find 7 such more questions that discuss in different case-based manner different aspects of the Contract Act, give you a brief of the important sections which are discussed in these, and help you to revise and understand in a comprehensive way your Indian Contract Act. You can download this PDF, as I stated again, from the link given in the description of this particular video. You can download our app for any further information or to access any free content or resources, and you can even visit our website iexambi.com or write to us at hello@iexambi.com or call us at 9205524028 for any further queries. Wishing you all the best for your phase 1 exam.